you. Okay, this is the preliminary hearing set in this manner. There was a petition filed August 23rd, 2028. I've had the opportunity to talk with the attorneys on a couple of different issues before we got started. For example, there is an order documenting that the first two children, Z and K, their last name is actually Miller. So that's one of the issues we talked about. We also set some dates for Mr. Joseph Miller's pretrial and trial, understanding his position from Mr. Brooks, and I anticipate some updates on Mr. McFarland's case as well. May I have the names of our participants, please?
Lee Heiss, lawyer guardian ad litem.
Ms. Stasia Thomas, counsel for the department. Ms. Harvey.
Sarah Harvey, DHHS.
Michael McFarland, representing mother. Please introduce yourself.
Stephanie Vargas.
Michael Brooks, I represent the father of two of the children, so Z and K. Z and K. Mr. Miller, would you identify yourself?
Joseph Miller.
Thank you. Deputy Ames, would you please swear in Mr. Joseph Miller and Mr. Stephanie Avalos?
You can remain seated, but raise your right hands, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Right. You know what? Before we get into that, any other comments on our sidebars, Counselor?
Well, from this point forward, I would like Z and K to be referred to by their correct last names as determined by the Ohio courts.
Any objections?
We have the order, Your Honor, so no objection.
I have no objection, Your Honor. There's no legal grounds to object to on that.
Ms. Heiss?
Your Honor, I'm going to not weigh in on that if that's so no objection, but I will investigate and we may have to revisit it at a later time, but no objection today.
Thank you. All right. Well, the court has received and reviewed the orders. And unless I get some other information, that will be the move going forward. If there's some other information that comes up before the next hearing, I'm sure we can address that.
Further on the sidebar, my client waives the court reading the petition. She's received it, she's read it, and I've also advised her of her rights.
Thank you. All right, Mr. Brooks, could you confirm if your client has received the petition?
I know he has because he's gone and looked at it with me. So I know he's got it.
All right, and would he like it read onto the record, or would you like to waive that?
No, I don't want it read on the record.
Thank you. All right, Mr. Miller, we'll go to you directly. Do you have any reason to believe that you would be either a member or eligible for membership in any Native American tribe or band?
No, no, Your Honor.
Do you have any reason to believe that your children are members or could be eligible for membership? Thank you. Same question to your client, Mr. McFarland.
She indicates no, Your Honor.
Thank you for confirming that. I have obviously the two orders that came in on the name change cases from the Ohio court. I also have a reference to a custody case, and there is a referee's recommendation and order from 2019 attached to the initial petition in this matter, which documents case number 11-36637 overlaps with our proceedings. Are there any other cases that the two of you are aware of that would concern the care and custody of any of these children? Ms. Avalos. Mr. Miller.
No, Your Honor.
Okay. Each of you have the right to an attorney at this hearing as well as any subsequent hearings, which is why you have the court-appointed attorneys that are sitting next to you. You're welcome to hire your own attorney, and that attorney would contact your public defender at any time. You have the right to have the allegations in the petition read. Both of your attorneys have waived that. You should also know that if you decide you would like a jury trial, you have to file that request in writing within 14 days. You have the right to seek placement of your children at this hearing and the right to deny or admit the allegations and make a statement of explanation as it relates to that petition. Any question about any of those rights, Ms. Avalos? No. Mr. Miller?
No, Your Honor.
Mr. McFarland, I think you know how your client would like to proceed, is that right?
I do, Your Honor. There are allegations of drug usage that my client allegedly admitted to. There's issues of possible child abuse based upon the petition. Therefore, my client wishes to enter a no contest plea, Your Honor.
All right, Mr. Brooks, do you know how your client would like to proceed?
We'd like a trial.
Thank you. We've secured the dates for that. For could you any of those?
Yes, so, trial is October 10th, 1:30.
And we
We
got
have a
a,
final pretrial on September 20th at 11.
thank you so much. Okay. Pending that pretrial and trial, Mr. Brooks, any requests?
2, Your Honor. 1, my client hasn't seen his children in 7 years. I think it's pretty clear from the preliminary information you have that he is a wronged party. Also, his children have been wronged. I would like some parenting time as to get reintroduced to his children between now and October the 10th. I'm sure right now, based on what I've read in the petition, that they think their father is some kind of monster, thanks to the mother's lies. And I want them to see a chance he's a normal human being. I'm not asking for custody right now. I don't think that's realistic, although I do have an objection to the appointment of the mother's husband as the custodian. We'll get into that, but I would like to see some reacquainted period. Some weekends, parenting time, not overnight, but so that he can get to know them, so they can get to know him. So they can see what his face looks like, so they can hear what the sound of his voice is. They don't know. And he doesn't know what they sound like. I mean, this is just egregious behavior.
If I could respond, Your Honor.
And I'm not done.
Sir.
And I would like the court to, just on a temporary basis, let these 3 folks get a look at each other and talk to each other. Please. That's request 1. Request 2 is I would like an alienation evaluation done on these children to see what this woman's done to these kids over the last 7 years. Sounds like it's quite a bit. And I think we need an objective third-party evaluation to inform the court of just what grounds for my client's extreme frustration is with this whole process. And I'd like to have that. And although I know he doesn't know what it is, once he understands, I think he'll agree with me. That's a good idea.
Mr. Brooks, have you talked with your client about any relatives that may be familiar with the children that would be available to provide care?
I highly doubt if any of his relatives at this stage are familiar with his children, but I'll ask him now. Sir, she's asking if you have any relatives who you would feel would be appropriate to take temporary custody of these kids.
Yes,
Who?
my sister Sue.
What's her full name?
Sue Kiltz, Susan Beatrice Kiltz, but she lives in Kentucky.
That's a problem. Because court doesn't have jurisdiction in Kentucky.
And no, not at this time.
No.
Thank you. All right, Ms. Thomas, would you like to respond next, or would you like to hear what Mr. McFarland has to say first?
I would wait until Mr. McFarland has his opportunity.
I guess I neglected to say that in our sidebar, we did contact the friend of the court. There is an order from 2019 suspending Mr. Miller's rights through the circuit court for visitation of these children. So I agree with an alienation evaluation. We'll get to the bottom of also why his rights are suspended. We also indicated there's $8,200 and some dollars he's behind in child support arrears. He's made, I think, about 4 or 5 payments of $60 each, last one being in June of this year, according to what the friend of the court indicated. My client, my understanding is that the minor children have expressed that they wish to stay with their stepfather. That's my client's thoughts, but she does have an aunt, and her name is Christine Miller, who she would like to have considered if the court finds that unacceptable, Your Honor.
Oh, Christine Miller.
No relation to me.
All right. May I respond, Your Honor?
Sure.
I would like to point out that all the while this alienation was going on, an active partner of this woman was the very person they want to put these children back with. I have no confidence that he won't continue the campaign of besmirching this man, his character, his suitability as a father, and I am opposed to it.
Okay, Ms. Thomas, your position.
Your Honor, I believe that during direct with Ms. Harvey, I could ask questions as to what her investigation has revealed, I suppose, about these issues. But as it relates to parenting time, that's generally something I would say for closing. I think that in these types of situations where we don't have any connection for 7 years or so, we have a 13 and a 15-year-old. They are of a suitable age to express some sort of preference. And of course, I think that a parental alienation evaluation is totally reasonable. But I also think that it's appropriate to begin with some therapeutic services for both sides, both children and adults here, and find a way to have a therapeutic reintroduction phase.
Ms. Heiss?
Thank you, Your Honor. The children have had a recent trauma with their mother's mental health and her seeking treatment. They were to start school today and they're already here. They have told me that they need and want to stay for the short term at least with Mr. Avelos. They have two siblings there with whom they are very bonded and have been a part of those two kids' lives, and that would be very disruptive to the little ones. So although I'm not opposed in any way to a parent alienation report, and should there be findings of parent alienation, we're just meeting this family today, but if that is true, that we have resources to back that out and to make this family healthy again. But I can't do that overnight. So I can't get these children to leave what they call home with who they call father. This would have to be a direct placement. The agency does not oppose my request, but they are not asking that you place the children with them because Mr. Avelos does have some concerning criminal history, pending criminal history, and placement may have to be moved shortly, but in one day, on the first day of school, I think that is to change their placement is not in the children's best interest. Thank you.
May I respond to the GAL's comment, or may I not?
Let's take some testimony and then we'll continue the conversation about visitation and placement.
Oh,
All right. Well, just to clarify positions, Ms. Thomas, are you asking, I know the petition is asking for removal. Are you asking for removal?
Your Honor, per policy, the department, that is what we have to ask for, at least for the two older children. There was hope that the children could remain in their home. The other request is for mom to be ordered out of the home. It's my understanding she, I think, has been voluntarily doing that as it is. But right now, that's where we are. Again, I would like to have more testimony from Ms. Harvey as to whether a direct placement could be appropriate for this family.
Thank you. Your formal position, Mr. McFarland, on removal?
I'm sorry, I was discussing with my client
That's okay.
another matter. What was the issue?
My understanding is your client has been out of the house under a safety plan, more or less.
Let me ask. My client agrees to remain out of the house, Your Honor. The marriage we was discussing, we have two other parties who are actually interested parties who are in the courtroom. I don't know if the court needs to make note of that or not, just minors.
Thank you. Your position formally, Mr. Brooks?
well, let's start with this. I don't believe a word this woman says. She has been adjudicated or determined to have committed fraud under oath twice, one for each child, in the Lucas County courts. How do you know? In fact, I'm quite confident that she would lie to you about what she is and isn't doing, both with going into the home and with what she is or isn't saying to the kids. You're gonna get her to stop after 7 years saying the father's dead? You think she's gonna stop? Based on what? No, the children have to be removed. As for Mr. Avalos, he's not here. He hasn't had to respond to anything, but he's been right there while all this is going on. I think he probably knows that this gentleman who's sitting here with me is not dead. I'm pretty sure he knows it, and he allows this to continue. That poisoning has to stop. Now, is it harsh? Yes, it is. Is it going to upset these two children? Yes, it is. I don't like it, but I also don't like what has happened to these two kids up till now. Their brains have been poisoned, and poison is the appropriate word. Whose fault is that? Hers and the man she's married to. No, she should not have them. No, they should not stay in that house one more minute. I don't like it, but it's best for the kids.
All right, Mr. McFarland, can you clarify whether or not your client continues to be married to Guy Avalos?
Yes, that's affirmative, Your Honor.
All right, testimony, Ms. Thomas.
Your Honor, I would call Ms. Harvey and then also ask if it is Ms. Varga Avalos's intent to, contest that it also serve as the factual basis for the plea.
I'm sorry, I didn't hear what you said, that you broke in and out.
We would accept the petition as a factual basis for the plea.
Okay, thank you, Mr. McFarland.
Thank you.
Absolutely.
You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Good morning. Ms. Thomas.
Thank you, Your Honor. Ms. Harvey, can you please state your role and familiarity with this matter?
I am a CPS investigator for DHHS, and I was assigned to investigate allegations against Stephanie.
And the allegations were in fact solely against Ms. Varga Avalos, correct?
Correct. My initial allegations were just against Stephanie.
And in your investigation, did you discover that Mr. Avalos is not the legal father of all children in the home?
Correct. He is the legal father to the two youngest children, G and A. He is not the legal father to the two oldest children, Z and K.
And in your investigation, what concerns did you have regarding Ms. Avalos or Ms. Avalos?
The original allegations came in with improper supervision as the allegation. I added an additional allegation of threatened harm of physical abuse. On July 8th, Ms. Avalos was riding in the car with three of her children. She was agitated. The children described her driving as erratic. One of the children texted Guy Avalos indicating what was going on in the car. He then got with Stephanie and asked her to pay attention, that she needed to not drive erratically. That upset Stephanie, and she stated that she should just drive her car with herself and the children into a lake. Then Guy Avalos would not have any family left, and that would hurt his feelings. It was discovered through interviews with the girls that this type of suicidal threat and emotional manipulation, so to speak, was common in their home. She often threatened suicide in order to get the children to do what she wanted them to do, or if they had in some way hurt her feelings. all of the children, all four, indicated that they were not safe with Stephanie. The day of the incident, Stephanie was taken to the hospital and admitted to Stonecrest for treatment. I asked them if they would feel safe after their mother received treatment, and they all indicated that they would not be safe. The two oldest girls were very expressive in their opinions and stated that they know that their mom has not been taking medication appropriately. She often essentially zones out. There are times when the children have to leave notes around the house reminding her when to pick them up from practice because she is incapable of just remembering and coming to practices. There tends to be a wide array of moments where her mental health was standing in her way of parenting.
And do you believe that based on your investigation and what was told to you, that the children would be at a substantial risk of harm or continued substantial risk of harm to their life, physical health, or mental well-being if they were to remain in the care and custody of their mother?
Yes.
And based on that opinion, did you investigate whether the two oldest children had another legal parent that they could safely return to or release to?
Yes, so I was given the name of Joseph Miller. I immediately got the friend of court order, which showed that his parenting time was suspended in 2019. That was in full alignment with what Stephanie had told me, that he had not seen the children since 2016, and that in 2019 a court order went in place to suspend his parenting time, which is what the court order said. It was also in line with what the girls both indicated when I spoke to them about the last time that they had seen Mr. Miller, or what their thoughts were on Mr. Miller. Both of them indicated that it was approximately 2016 when they had their last memories of seeing him. Our address and phone number in our computer system was not accurate. We then did various searches online and through the friend of the court and payments through child support to find the address for Mr. Miller. We sent a courtesy worker who made a couple attempts face-to-face. Mr. Miller's apartment complex is secure, so you cannot knock on his door. You have to essentially be outside. It's locked to get into the doorways. We did not have a accurate phone number for Mr. Miller, so we did send all of his documentation through the mail.
And during your investigation period, through front of the court, were there any other documents indicating that there had been any movement through the front of the court case or custody case since 2018?
No, there was nothing that came to us since 2019. There were previous hearings and previous requests back and forth, but there was nothing after the 2019. It was the most recent that we were given.
And at that time, did you have an opinion as to whether the children would be at a risk of harm if they were to be in his care and custody?
I didn't feel that it would be in their best interest. I did feel there was a risk of harm. There was some DV allegations by the oldest child, by Stephanie herself, and some other people in Stephanie's life that indicated that there was an issue with domestic violence in the home while they were there. And both of the girls indicated that they did not want contact and they were fearful of contact with Mr. Miller.
Do they indicate whether that was based on their own memories or that of something someone else told them?
The oldest does indicate that she does remember a domestic violence incident in which I believe a wedding ring was thrown at Miss Avalos or Miss Varga Avalos and hit her in her head. The younger one was too young to have those memories for herself.
Thank you. And at this time, there's been some conversation or discussion, I guess, about whether Mr. Avalos can be considered a relative placement for the older two children. Can you explain what the department discovered in that inquiry and what the department's position is?
So as part of our investigation into any placement, we do a criminal history check. Mr. Avalos does have some more recent past criminal history and a current outstanding charge, which does stop us from saying that he would be our requested placement.
To the best of your knowledge, are any of those offenses violent in nature or assaultive in nature?
Yes, the previous history does have some domestic violence charges. They were started as a different charge and pled down to a domestic violence charge. The current charge does not include any assault.
And how long ago were the DV charges, to the best of your knowledge?
To be honest, I know that they were within 3 years, but I don't know the exact dates.
Do the children have any fear of Mr. Avalos, to the best of your knowledge?
No, they've actually indicated that he has been their safe person through this experience.
And do you know about how long Mr. Avalos and Miss Varga Avalos have been married?
I know that they've been together for 9 years, but I know that they were not married that whole time. I want to say 2 to 3 years, but that's just based off my memory.
Okay, thank you for that information. And if the court were to do a direct placement, would the department have, based on the information you've discovered, would the department oppose that in any way as it relates to the children's safety?
We would respect the court's ruling.
In the 2 younger children, you are asking that they just simply be released to their father, Mr. Avalos, under the supervision of the department. Is that correct?
That's correct.
As it relates to parenting time, do you have a recommendation for parenting time for both respondent parents at this time?
My recommendation for parenting time is that parenting time be suspended until a full therapeutic parenting time evaluation and process can begin. These children, all 4 of them, have substantial trauma. I want to put in referrals for CTACs so that we can get a full trauma assessment and then begin the process of parenting time after that. I think it's just too soon for any of them. I think they need to process some of the trauma before they integrate into parenting time.
And when you talk about the CTAC assessment, can you just inform everyone what that acronym means?
So it's a children's trauma assessment. It's fully intensive. It will look at the long breadth of history, not just what's currently going on. So it will give a very accurate account of trauma. It talks also with families. Stephanie will be involved, Guy will be involved, Mr. Miller will be involved. That way you get a full picture of the trauma and how the children are dealing with it.
And is there an element for a bonding assessment?
Yes, it can be done. Bonding assessments can be done.
And in the parents' defense, that process sort of takes a long time, correct?
Yes, it does.
And so what would be the mitigation to the deterioration of a bond between the children and their parents in the meantime?
Currently, as it relates to Mr. Miller, there is not a bond. So it would not be a detrimental in any way. We could only move forward in that case. As it pertains to Miss Avalos, the children right now, the older children do indicate that they could use a break from the parenting time. There have been some moments during parenting time where there have been inappropriate comments. There have been text messages sent to the children, which offer a manipulation piece. I just don't feel that we're at a space where that parenting time is able to be monitored. I believe that we would start into parenting time and then we would have to stop the parenting time, and that would cause more of an issue for the kids.
Thank you. And is there anything else you would like to bring to the court's attention today?
Not at this time.
And if the court does not order direct placement for the two older children, have you been able to approve, I guess, per policy, Miss Christine Miller as relative placement?
Yes, we have done all of the checks and she has been approved as a placement for the two older girls.
And would that keep them in the same school district?
No, not only would the girls be separated from their younger siblings, they would then reside in Wayne County.
Okay, thank you. I have no further questions, Your Honor.
Okay, Ms. Brooks?
Is this other Miller person related to my client in any way?
No, not in any way.
Okay. What is Mr. Avalos' criminal history over the last 3 years?
I don't have that information right off the top of my head, to be honest. He wasn't, and the allegations weren't against Mr. Avalos. So that part I didn't record to memory.
Fair enough, fair enough. All right. That's all. Thank you.
Are you aware that when Mr. Avalos was convicted of domestic violence, that he still was able to have contact with the two older minor children in this case? Are you aware of that?
I would assume that because he lives and resides in their home and there was no contact order in place right now.
And this domestic violence history did not involve minor children or the children in this case, correct?
To my knowledge, no.
Okay. And are you aware that he's currently on probation being monitored by the courts for his
Yes.
behavior?
Yes,
Okay, and he's not been violated with that at this point, correct?
correct.
Nothing further?
Ms. Heiss?
Thank you. Mr. Avalos has been approved by the agency for placement of the younger two, correct?
Yes, we have no allegations against Mr. Avalos.
And his criminal history doesn't prevent him from having placement of his own biological children, correct?
Not at this time, not from his biological children.
So the reason the agency doesn't recommend placement of the older two children with DHS than placing with Mr. Avalos is because they are not his biological children, correct?
That's correct.
So there's a different standard for them. The older two children are 15 and 13, is that right?
Yes,
And they're verbal and they're able to articulate to you if there's a problem?
yes, they express themselves very well. They do a very good job of advocating for themselves.
And what is their wishes?
Both of the girls have indicated to myself that they want to stay with Guy. They feel that Guy has kept them safe during this time, and he will continue to do so. They both see Guy as the father figure in their life. They want to stay with their younger siblings. They fear for what their younger siblings will go through if they are not in the house, and that form of stability isn't maintained.
So in your petition, you're alleging that Mrs. Avalos has been diagnosed with a mental health condition. Is that true?
That's correct.
And she hadn't been medicating appropriately and maybe over medicating in other ways. Is that true?
Yes, there were indications that it wasn't appropriately being medicated.
And although she's had treatment at this time, are you recommending or that there be no contact between Mrs. Avalos and the children outside of visits?
Yes, outside of visits, I think that it would be inappropriate, as we've seen some issues already.
Okay. That concludes my questions. Thank you.
Redirect, Ms. Thomas?
No, Your Honor.
Any recross, Mr. Brooks?
No,
Just one question based upon the guardian items. Are you requesting that neither parent have contact outside of visitation? No Facebook, no social media, no texting, no
Correct.
contact like that?
Until we can get the full trauma assessments done and see where we stand.
Father and mother, right?
Correct.
Thank you.
Okay, thank you for your testimony. You may return your seat. Okay, any other witnesses, Ms. Thomas?
Not at this time, Your Honor.
Anyone you'd like us to hear from today, Mr. McFarland?
Nope.
Mr. Brooks?
although I'm sure it would be rather theatric, I'm asking the court to take my word for it that my client is extremely frustrated over this woman's behavior and that of her husband, and the way he's been treated and the way that his two children have been treated. And I ask you to grant him immediate parenting time with an ultimate goal, I'll be perfectly blunt, of getting custody of these two girls away from their mother. But for now, I want the alienation evaluation, and I would like to see him have parenting time with his girls immediately. Just imagine, they're teenage girls. They don't even know what the sound of his voice is. That's obscene. Please give him some parenting time.
Okay, anyone you'd like us to hear from, Ms. Heiss?
I don't have any witnesses, but I have interviewed my client and would like to make a report regarding that.
Go ahead.
Your Honor, the children do wish, the two older children who I interviewed do request to be placed with Mr. Guy Avalos, at least temporarily. They indicate to me that they are doing well in school. Today was to be their first day of school, but generally they understand that attendance and grades are very important, and they're generally well-behaved children, and they will the visit. They are also counseling. They understand
You're breaking up, Lee.
Mandatory. Sorry about that. The children wish to stay with Guy Avalos. Thank you.
All right, well, for purposes of the prelim and removal, I think that about sums it up, with the exception of the plea that your client wishes to enter, Mr. McFarland.
Correct.
Okay, please come on up to our seat.
Yeah.
Raise your right hand, please. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Here's a step to take care of it.
All right, we may have to go, as you're aware. First of all, is there any objection to Ms. Avalos entering no contest plea?
I
No, Your
have no
Honor.
objection.
No objection.
No position, Your Honor.
Thank you. Ms. Heiss, do you find it to be in the best interest of the children for the court to accept no contest plea?
Yes, Your Honor, I do.
Thank you. All right, Ms. Avalos, if I accept your plea, you are giving up the right to a trial by judge or jury, the right to have the petitioner prove the allegations in the petition by a preponderance of the evidence, the right to have witnesses against you appear and testify under oath at trial, the right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. You understand you'll be giving up or waiving the rights I've just indicated to you if you enter a no contest plea? I'm sorry, you'll have to speak up to the microphone and speak very clearly. Yes, thank you. With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there is no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home in order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea? Yes. Thank you. Do you have any questions about any of the information I've given you so far? Are you under the influence of drugs, alcohol, or any other mental or physical condition that could interfere with your ability to understand what you're doing right now?
No.
Is anyone making you or forcing you to enter a no contest plea?
No.
Has anyone threatened you in order to get you to enter a no contest plea?
No.
Has anyone promised you anything in order to get you to enter a no contest plea?
No.
Would you say your decision to enter a no contest plea, which is in effect an admission of the issues in the petition, a decision of your own free will?
Yes.
All right, just to confirm, I'm to use the testimony of Ms. Harvey and the petition as the factual basis of the plea, counselors?
Agreed.
Yes, Your Honor.
Yes, Your Honor.
Thank you very much. Okay. Mr. McFarland, and the rest of the attorneys, are you satisfied with the factual basis of the plea and the advice of rights?
I am.
No opinion.
I'm satisfied.
Thank you. Thank you for your testimony. You may return to your seat. Court finds the plea to be knowingly, understandably, and voluntarily made with a full understanding of the consequences. I further find the record supports that one or more of the statutory grounds alleged in the petition are true. I am to consider the statements in the petition as well as the testimony of Ms. Harvey. Thank you for your investigation. It does appear that there is a risk of harm to the environment of the children with their mother there as a result of her untreated mental health issues that she has used as a way to manipulate and harm their mental health and potentially their physical health by failing to undertake many of the parental responsibilities that she normally would have to undertake, such as attending medical appointments, attending educational obligations, and assisting the children in those endeavors. We have the criminality aspect, which is the reason why the court has accepted a no contest plea, which is the reckless driving of this parent with the children in the car, threatening suicide and homicide of herself and the children. The untreated mental health issues are outlined therein as well, and forms the basis for many of the issues that are arising in that home, such as the ones that the court has already described and that are more detailed in the report. So I do find that the home is compromised, as well as the children subject to neglect as a result of mother's actions in this file, and that jurisdiction of the court is appropriate over the children as well as over Stephanie Avalos. I agree, and I'm glad to hear that the children are already in counseling. I'd like to have copies of the initial 30-day trauma screenings. And obviously, if there's any CTAC evaluations that come back, we'll look at those as they arise. The court will order the parental alienation evaluation. Ms. Thomas is familiar with that process. She can assist you with who that person would be. As it relates to visitation with Mr. Joseph Miller, I find that it's appropriate to acknowledge that he has acknowledged himself he has not seen these children in 7 years, and that break in their relationship, along with the perceived trauma that they have around that, could cause some harm to them on a mental health basis if I were to allow visitation immediately. So I will ask the parental alienation evaluator if that person is comfortable with a recommendation. If they're not comfortable with that, or perhaps in conjunction with that, we could consult Ms. Brene Moore immediately to have an evaluation as it relates to parenting time with the older two children. But as a result of the effective abandonment of these children for that period of time, that will be the cause for formal removal of the older two children from their father, Joseph Miller. It's also reflective of the court's review of the last friend of the court order, which does reflect suspension of his parenting time back in 2019. And as Mr. McFarland shared, that has been confirmed that that order still remains in full force and effect. So because of those concerns, that will be the order moving forward as it relates to Joseph Miller. and parenting time with his 2 children, as well as the formal removal of these children from his care. As it relates to all 4 children, the younger 2 children are approved for placement with their father, Mr. Avalos, and I will honor the request of the older 2 children to remain placed with Mr. Avalos at this time. That will mean that there will be a formal order entered prohibiting Stephanie Avalos from entering onto the premises. Moving forward, that will be enforced like a personal protection order. If you step foot onto that property, Ms. Avalos, outside the permission of the Department of Health and Human Services, that will be cause for the children to remove the children from Mr. Avalos. Do not compromise their placement with them. Do you understand? Thank you. Will be no contact between these children and their mother outside of supervised parenting time, either conducted by the department formally and the agency and or a therapeutic interventive process. And if that's compromised, that compromises the placement, period. Understand me, Mr. Avalos?
Yes, ma'am. Thank you.
The reason for the removal of the mother from the home is in fact the same basis for the court to assume jurisdiction and to accept the factual basis of the plea. That will continue moving forward. Ms. Harvey or the agency, whoever will be taking over at this point, will be working with the family and with you, Ms. Avalos, to formulate a case services plan. We encourage you to get started on that as soon as possible to take care of yourself, your mental health, and get on the pathway to reintegration of yourself into the home of your children. We've already started therapy. So good. Ms. Harvey will be the point of contact on any of those efforts. We should report those to her until and unless she tells you otherwise. All right, our next court dates are already established. That September 20th at 11 a.m. hearing will also be the initial disposition for Ms. Avalos, in addition to the final pretrial for Mr. Miller. And hopefully we'll have some kind of evaluation back. So Ms. Harvey will need you to get those referrals out right away, and whoever bites first, frankly, just go in that direction. I'd love to have an update on parenting time and be able to look at that for Mr. Miller at our next hearing if possible. Okay.
One last detail, Your Honor.
Yes.
Given the history of this couple with these children of my clients, I would like them to be admonished that they should make no negative comments about Mr. Miller at all while they're in custody of Mr.
We agree, Your Honor.
Very good. I agree also, Mr. Brooks. So please be cognizant of that, Mr. Brooks. Keep that in mind. Thank you. Anything else, Mr. Brooks?
No.
We'll proceed then to the trial as it relates to your client, which has been requested as a bench trial as of today on October 10th at 1:30. Okay,
Thank you, Your Honor.
unless there's any questions, that's all for today. I'll have the order out to you in a few minutes.
Would,
Gerard, did you say October